Good morning, good evening, good afternoon. Our friend Joseph Brandon Pierce, Common Joe, apparently was found guilty of cruelty to animals. The jury recommended 1 year and a pretty hefty fine, 1 year in jail. So apparently Common Joe's sovereign citizen tactics don't work, which, I mean, frankly shocks me. In every sovereign citizen video online where sovereign citizens try sovereign citizen tactics, it fails. It always amazes me that these sovereign citizens appeal to cases and statutes that they think apply, and they don't realize that they're appealing to the very system that they think doesn't have jurisdiction over them to make these arguments. And it's just weird. It's just weird to me. Like a judge or appellate court justice or Supreme Court justice made these decisions, but you think that judges and justices and Supreme Court justices don't have the power to make decisions. It's crazy. So, justice for the pupper. I saw a picture of the pupper for the first time the other day, and that doesn't look like a mean dog to me, but I guess reasonable minds can reasonably differ. It will be interesting. There's apparently a recording of the trial. I might look into seeing if I can get a copy of it. I don't know how I would get a copy of it, but I know people like P-Docs and Big Jim Finch who know how to get those things, and I might slip them some money somehow to get those if that's possible. Because I think it would be interesting to see, because he may have walked out mid-trial and they may have continued the trial without him, which would be really interesting. And that might be grounds for appeal, or it might not. I don't know. Another thing is that I said the other day that the rule, not the exception to the rule, is that a violation of rights by cops isn't a crime. There has to be some sort of statutory mechanism in place that makes it a crime. And I was talking, I was basically addressing something that Rights On said, and I respect Rights On. He seems like a good dude. I have no trouble with him. And he responded back to that video with 18 USC 242, which on its face, if you read it, says that any violation of the rights or privileges or immunities secured under the Constitution or the laws of the United States is a crime. And that's great. I mean, like, on its face, it absolutely looks like I was dead wrong. I mean, I get it. I get it. On its face, it looks like I'm dead wrong. Unfortunately, as it's written, if it was just that simple, the statute would be unconstitutional. And the United States Supreme Court recognized that, and I think like Screws versus the United States, I think is the name of the case. And so to save the statute, the Supreme Court read in various things. Like, first of all, that the constitutional right has to be essentially clearly established. It has to be a set decision that puts the police officers and whoever else might be acting under color of law on notice that it would be a constitutional, or it'd be a violation of the rights to do the thing, right? So that narrows it down considerably right off the bat. But the second thing that they did is they made the mens rea requirement exceptionally high. Now, it's unclear from Screws exactly how it is, but various circuit courts have essentially said that basically you have to willfully do the thing that is a violation of someone's rights. You basically have to know you're violating their rights when you do it. Now, there's a lot of variations between the circuit courts on how they interpreted Screws and how they how they implemented Screws. So, your mileage may vary, but essentially the result of that is that about 99.9% of all rights violations don't meet the criteria to be charged under 18 USC 242, which is why you don't see most of the things that cops get sued for under 42 USC 1983. You don't see those getting charged, simply because the standard is so high that most of the things that the cops do don't meet the standard. So again, the rule is that it's not a crime to violate someone's rights. The exception to the rule is where someone acting under color of law willfully violates their rights, knowing or with reckless disregard of the fact that it is a clearly established right. So, I applaud Rights On for, doing some research, and that's great. Unfortunately, it doesn't change the analysis. The rule is that most, like 99.9% of all rights violations aren't crimes, even under 18 USC 242. And you might not like it, you might disagree with it, but there's a reason, and if you read Screws, you can see the rationale why the Supreme Court had to put those things in to keep 18 USC 242 within the confines of the Constitution. So basically the cops have to know what the law is that they're violating in order to do it. And just really quickly, it's because a lot of the Constitution hasn't been interpreted fully in all circumstances, and you can't put the burden on the cop to understand how a court's going to interpret that, because the courts come down all over the place all the time. So anyway, that's your news update for today. Really quickly too, I guess Earl did petition the Texas Court of Criminal Appeals, which is the highest court for criminal cases in Texas. It's their equivalent of a Supreme Court. Their Supreme Court just deals with civil matters. So the Court of Criminal Appeals is above the Court of Appeals in the criminal structure. So it goes like circuit or district court or whatever to the Court of Criminal Appeals, to the Court of Appeals, to the Court of Criminal Appeals. So anyway, thanks for watching. Have a great day.